Group of Louisiana voters urges Supreme Court to strike down major provision of the Voting Rights Act. Lawyers representing a group of Louisiana voters challenging the creation of a second majority black congressional district in the state told the Supreme Court on Wednesday that a key provision of the Voting Rights Act is inconsistent with the letter and spirit of the Constitution. The filing came in a dispute that could lead to a major decision on voting rights and redistricting. The dispute began several years ago when a group of black voters filed a lawsuit in federal court challenging the congressional map adopted by the Louisiana legislature in 2022. The map contained only one majority black district, although nearly a third of the state's population is black. The black voters contended that the 2022 map diluted the votes of black residents. A federal district court agreed with the black voters that the 2022 map likely violated Section 2 of the Voting Rights Act, which prohibits election practices that result in denial or abridgment of the right to vote. A federal appeals court in New Orleans upheld that ruling, and it instructed Louisiana to draw a new map by January 15th, 2024. If it failed to do so, the state could face the prospect that the district court would draw one instead. After Louisiana legislature adopted a new map that contained a second majority black district, the challengers in the case the challengers in the case now before the court, who describes themselves as non-African American, went to federal court where they argued that the 2024 map was an unconstitutional racial gerrymander. That is, it unconstitutionally sorted the state's voters based primarily on their race. A three-judge federal district court agreed with the challengers, but the Supreme Court paused the court's ruling, allowing the state to use the 2024 map in the 2024 elections. When the
Didn't do him any good. Come Queen Hyena Harris lost.
True.
She got her ass kicked. So anyway, it is what it is. Let's see what
Right.
happens. It's one of those interesting things that you can disguise if you're a law professor and you're smart and give as a question on a final exam to your students to see if they can come up with an answer. Particularly intriguing since the issues would be up in the air.
Well, I wanted to bring up the Voting Rights Act of 1965, and go to Section 2 where it says no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or implied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. So,
Yeah, what was going on is when this bill was passed, let's see, I was at UCLA, so I was taking political science courses. What's interesting, see, is this is a carryover from the literacy clauses, which in retrospect might not have been so bad except for their racial orientation, where black voters were required to prove that they could read, write, and comprehend certain things about American governance. That was just applied to black voters in the South, certain areas in the South. So that's what that's all about. That was to remedy an old Jim Crow situation. Exists now. Now we have some dumb, ignorant voters who don't know what the devil's going on. They just vote as they're told to vote, and they sheepishly do it, or they slavishly do it because they're used to whoever the shepherd is or whoever the plantation master or mistress is telling them what to do.
going back to this particular Louisiana case, right? It says when the case first came to Supreme Court, Louisiana told the justices that it was stuck between a rock and a hard place. On one hand, it needed to comply with the Voting Right Act. But on the other hand, it also needed to comply with the 14th Amendment Equal Protection Clause, which prohibits the government from treating people differently unless there is an adequate reason. So the first map eliminated a lot of black voters in their black district, even though they made up a third of the state. So they're saying, hey, we need to include, everyone fairly. But then the challengers who are non-African American said, hey, well, you can't create a map based on race.
What you had when you're talking about challengers is this: you had black voters versus the state of Louisiana. A ruling got entered and a direction looked like it was about to be taken when some other people who weren't viewing themselves as being either plaintiff or defendant in the original cause intervened, and they challenged the outcome that was dictated by the opinion or the decision in question. So uh, that is something I warn people about. Hey, it sounds good, but do you really think these other folk are going to go along with this?
So it says the non African American voters argued that the legislator had first made the decision to impose the racial quota of two majority black districts and then focused on politics. But even if compliance with the VRA Voter Right Act was Louisiana,
Voting
yes,
Rights Act.
was
Go ahead.
Louisiana's true goal, they wrote that shows that race was the primary factor driving its decision to draw the second majority black district.
Well, see, you run into, in that sense, there are cases that the U.S. Supreme Court decided that said when there is a remedial situation where there is a historical wrong that is obvious and blatant and needs to be corrected, then steps can be taken to correct the problem. In other words, the Supreme Court has long held that remedial efforts are okay, but once you restore normalcy, then you have to revert to the way things are, which is everything's got to be neutral.
Right. I want
And that's where we're running into a problem here. See, Louisiana does not have a very large population as states grow. So there are few districts. In New York, you probably have districts in the immediate environs of New York City than you have in the entirety of the state of Louisiana. So the problem goes is if you want to include black folk in arranged and drafted districts so that they have some influence as a body, how do you do it without putting in what is in effect a quota system, or to be fair to them without being unfair to others? See, in other words, you can't rob Peter to pay Paul.
right. So I want to read this section here. The Supreme Court heard oral arguments in the case in March. On June 27th, the justices announced that they would hear arguments in the case again during the 2025-2026 term. They later directed the li- litigants to
Litigants.
address specific question whether Louisiana's intentional creation of second majority black district violates either the 14th Amendment or the 15th Amendment, which bars both the federal government and states from denying or abridging the right to vote on account of race, color, or previous condition of servitude. Both amendments were enacted in the wake of the Civil War in an effort to establish equality for formerly enslaved persons.
Well, see, here's the problem. a lot of vote counts don't have a direct impact. In other words, let's take the Electoral College. The Electoral College equates to a board of directors. The stockholders in a corporation board of directors. The voters in a state elect the Electoral College. The board of directors selects the CEO of the Electoral College selects the president of the United States. But you see, in most states, what happens is it's winner takes all. Or what also happens is a situation with Jasmine Guy, where you get
Crockett.
yeah, Jasmine Crockett. Jasmine Guy is all right. Jasmine Crockett is a coonskin headed, wig wearing, barn door, eyelash wearing freak who fronts off on trying to be street girl when she's just as boule as it gets. Now, back to this. What winds up happening is you get these various and sundry districts. So, okay, if you poll the people in Texas, they would find overwhelmingly, in terms of the majority, that Jasmine Crockett is an abomination that they wish they could get rid of. But the voters in her district, as it is currently construed, apparently like her. That's part of this thing about American politics that says you get the representation that you deserve. And if the district is a bunch of idiots, then they get an idiot representing them that harms the entire state. So what happens is there's a fight over how you district the state so that you don't get Jasmine Crockett idiots running stuff and having a disproportionately influential say on what happens to everybody else. Now, that's what's going on in sort of an exaggerated sense in Louisiana. It's like, what happens with these districts, since the district can be construed to have a majority of black voters. So you have few congressmen. So the small number of overall black voters get a disproportionate effect in terms of how they cast their votes on the outcome of political matters that affect the entire state. Okay, for example, you can take 250,000 black voters and you can divide them up into three districts. So what winds up happening is the 80 some thousand in each district can't control it. They can influence it, but not control it. So what happens is that the majority in the three districts control what's going on. Or you can say we concentrate all 250,000 black voters in one district that we draw in a strange fashion over here. So these 250,000 can have a congressional representative, which may be, you got a huge population in that state. So 250,000 people get undue influence relative to everybody else in the state. That's what the
So
whole
it
thing
says
is
here,
about.
in briefs filed at the Supreme Court last month, Louisiana argued the justices to leave the lower court's ruling that struck down the 2024 map in place, telling them that it wants out of this abhorrent system of racial discrimination. Race-based redistricting is unconstitutional. The state wrote, even if it occurs as a result of a desire to comply with Section 2. The black voters, by contrast, continue to defend both the 2024 map and the VRA, telling the justices that the law is the crown jewel of the civil rights legislation. In their briefs on Wednesday, the non-African American voters argued that Section 2 heavily impinges on state sovereign power to regulate their elections and draw congressional districts. Moreover, they added remedial race based districting cannot extend indefinitely into the future. The voters argued the Supreme Court to send the case back to the lower court quickly with instructions to expeditiously finish what it almost completed in early 2024, a map based on traditional redistricting principles unburdened by the VRA quota. Lastly, in a separate beef, in a separate brief, Louisiana Secretary of State Nancy Landry agreed with the state's argument made in its brief on August 27th that Section 2 violates the Constitution. But in any event, she added, because Louisiana's Black population is geographically dispersed, the creation of a second majority Black congressional district by slicing and dicing various communities, sometimes hundreds of miles apart, runs afoul of the Equal Protection Clause of the 14th Amendment.
Yeah, it's like that's why they call it gerrymandering, because it looks like a salamander instead of a box or a geometric shape. And it was a dodge. It was developed back in the late mid 19th century to give certain political factions control of the politics in a given state. The problem is that the Voting Rights Act and the Civil Rights Acts that go from 1964 up to about 1968 are somewhat sacrosanct. They were necessary to the then current circumstances of the United States to correct some very egregious wrongs that were in place. But like anything, as determined by the U.S. Supreme Court in its first case, the law in the United States is based on one, tradition, precedent, and three, the evolving conditions of society. Now, I know a lot of right-wing types are talking about the law is not supposed to evolve. It's supposed to remain as it was when the Constitution was adopted. Well, the Constitution was adopted in 1789. The Bill of Rights was adopted in 1791. In this case, comes from 1792, and every single one of the U.S. Supreme Court members that constituted the unanimous majority had either been involved in the Declaration of Independence, the Revolutionary War, the Confederation, or the adoption of the Constitution and or the Bill of Rights. So they knew what they were talking about, and they were unanimous in declaring that all law in the United States is subject to tradition, precedent, and the evolving conditions of society. And over the last 60 years, since 1965, what happens is society here has evolved. A lot of the problems that existed in 1965 no longer exist today because they've been corrected. Now, what happens is, well, do you change the law? Do you say, well, I know we meant well, but this might be unconstitutional, so we have to correct it? Well, Jim Crow was constitutionally okay for a while. Plessy versus Ferguson, separate but equal. And then finally, in Brown v. Board of Education, honchoed by Thurgood Marshall, the U.S. Supreme Court said you cannot have separate but equal because separate is inherently unequal. So we get changes.
Yeah. So, and let me just note here, when they say non-African Americans, that doesn't mean white people. It means white, Asian, Latino, anything other than black.
No, well, yeah. I mean, other folk in this country, see, you listen to the rhetoric and you assume everybody is either white or black or some mix in between. And then you have the Mexicans, which are something else. We don't know quite what the average person thinks, and that's got a lot to do with the federal application. Are you Hispanic, non-Hispanic? If it says Hispanic, then you skip the next bunch of boxes that go to Native American or Alaskan, Pacific Rim, Asian, white or Caucasian, black or African American, and you skip over all these other designations. So, but then again, you have Chinese, and what is Hispanic? My stepmother was deemed Hispanic, but her ancestry was almost exclusively Chinese. She was from the Philippines. So, I mean, what are you talking about here? I have a Taylor, C.C. Myers. She has a German last name because her parents came from Nazi Germany and they fled what happened when the Allies won. And she was from Argentina, but she's classified as a Hispanic because she hablas español muy bien. And that's the family language that she declared. So it's confusing when you look at it.
I want to play.
And then there are mestizos, mulattos, and all sorts of other things that get qualified in this. So what are you talking about? But all of these things have to be worked out eventually.
I want to play this clip here. Because this does go and pertains to racial and gender quotas.
Recognizes Ms. Mace from South Carolina.
Thank you, Mr. Chairman, and good morning. The government of the District of Columbia, under the leadership sitting in front of us today, has become a poster child for DEI and gender madness. This has led to government. Mr. Chairman, this is not a concert. This audience can just settle down.
Stop the clock, and the gentlelady's right. Under the rules of the House, the chairman is responsible for maintaining order and preserving decorum in the committee room. I expect audience members to be respectful of the committee, so
I'd like to reclaim my time, too, Mr. Chairman.
Absolutely.
This has led to government-sanctioned racial discrimination and the erasure of women. Article 1, Section 8, Clause 17 provides Congress plenary authority over the District of Columbia. Using this authority today, I'll be introducing the No DEI in D.C. Act. This bill will rip the DEI and gender bender nonsense out of the D.C. government root and branch, and restore common sense and equal treatment under the law. As the individuals charged with writing D.C. laws, signing D.C. laws, and enforcing D.C.'s laws, we have some questions for you on the meanings of some of the curious terms we have found in the D.C. Code. My first question for Mayor Bowser, it's yes or no. The D.C. Code makes numerous references to, quote, structural or institutional racism. Do you believe the D.C. government is structurally or institutionally racist? Yes or no? Yes or no? Is D.C. government racist, institutionally racist? Yes or no? All right, you can't answer the question. So my next question for Mayor Bowser, since you're going to sit there and placate or just be quiet, in Section 7-1234.02 of D.C. Code, you use the phrase child welfare involved birthing people. Child welfare involved birthing people. Can you explain to me what this means?
I'm not that familiar with that part of the code.
Okay, and so you don't know. In Section 7-1234.02 of D.C. Code, you use the phrase justice involved incarcerated and homeless birthing people and their non-birthing partners. Can you explain to this committee what that means?
I would have to see
You
the
don't
whole
know.
section.
You're literally the mayor of D.C. and you don't know your own code of laws.
Well, I don't know
All right,
them
one thing we
verbatim.
noticed the D.C. Code struggles to define is the term woman. So Mayor Bowser, what is a woman?
I'm a woman. Are you a woman?
100%.
Okay.
100%.
I'm a woman. You're looking at one.
Okay, good. You actually, in Section 3-703 of the D.C. Code, you use the phrase, the intersectionality of gender and race to create unique dynamics and effects. Can you explain what this means to the committee?
Where is that, ma'am?
Section 3-703 of the D.C. Code. Do you know what that means? No,
could
you
you give
don't
me
know
the
what that means.
title
So
of the-
Chapter 14D of the D.C. Code establishes
Mr.
the
Chairman,
commission.
I'm happy to answer questions.
Mr.
but
Chairman, I'm going to
can't-
reclaim my time. This is not her time, it's my time. You can be quiet as I ask you questions, and then you can
recognizes
answer them.
Ms.
And then you can
If
answer
you
them.
would give,
I'm not, Mr. Chairman, this is my time, not hers. I'd like to reclaim my time.
Let's make good use of the time, Ms.
Chair
Mays.
I'm making very good
Chair
use of my
recognizes
time.
Ms.
There
Mays.
And you're
is-
Ms. Mays
making
has
my
the
point.
floor.
You're the mayor of DC and you don't even know your own code of laws. What is a birthing person?
I would assume it's someone who gives birth.
All right. Why don't you use, are these women? Are these moms? Do you think it's appropriate to call them birthing person? Can a man birth a person?
Well,
Be a
that's
birthing
what I
person?
would call it, but I don't write all the laws, and I'm not familiar with every
Can
section.
men get pregnant?
No.
Can men become women?
Can a man become a woman?
Yeah. Can a man
If
become a
you're-
woman?
Miss
Yes
Mays,
or no? Can a man become a woman? Yes or no?
Miss Mays, I'm not here
Okay,
to
my
talk
next
about that.
question, Chapter 14D of the DC Code establishes the Commission on Reparations and a reparations fund to provide eligible African Americans monetary reparations or other forms of redress. Is it the position of DC government benefits should be provided to individuals on the basis of race?
I believe that the legislation requires a study.
Okay, I'm asking you, is it the position of the DC government that government benefits should be provided on the basis of race?
If you're
is the
referring to
question.
that legislation, I believe it requires a study.
Okay, I'm asking you a question. Do you believe that government benefits should be given out on the basis of race? That is the question. This is the third time I'm asking.
We have any number of benefits programs, and eligibility is
Okay.
established.
You're not answering any of these
per program.
questions. I'll give it to you. You're slick. In Section 2-1383 of the DC Code, you use the phrase social value of the LGBTQ community business economy to the district. Can you explain what this means to the committee?
It means that LGBT businesses provide economic benefit to the district's economy.
Do you think all businesses provide economic benefit to the DC economy?
They should, or they would be out of business.
Yeah, of course. All right, thank you, Mr. Chairman. I yield back.
Thank you. Chair recognizes
Okay, translation. This is an instance where the mayor, who is analogous to an NFL coach or an NBA coach, not knowing the rules in the rule book of the game that he is coaching a team through. So, how can you be the coach if you don't know the rules of the game?
Right.
That's what I've said too often. The case is that the people running stuff are ignorant of the laws that pertain to what they're running. And it's a good trap that she got caught in the middle of. I like her answer about being a woman. I mean, that's more sense than that idiot
Scratch it.
scratchy it, with due respect to her honor. Actually, I found that kind of embarrassing, but anyway.
Right. So
Hey man, do all of your women judges scratch their head like that, man? Isn't that kind of impolite? Shouldn't they just change to another wig, man, that doesn't itch
well,
like
here's the thing.
that?
So let me just swing it back to when I brought up the Louisiana Voting Rights Act case that's going to be in front of the Supreme Court, because their claim is, you cannot make a decision such as redistricting under race based. So we're talking about quotas. And I wanted to play this particular clip because she touched on race based reparations and she touched on gender, as well.
Let me just add one thing
I just
very
wanted to make that
briefly. Yeah, but in something that was brought up here, you go to DC. I've been going regularly over the years. Hell, I was born there, worked there too. But this thing bothered me. I was trying to meet up with one of my sons for lunch, and we couldn't find a single restaurant or eating establishment for a long time that wasn't plastered with rainbow paraphernalia or emblemage. So it's like we didn't want to eat in one of those places. So what gives? And then you see the sidewalks then were painted with all of this DEI rainbow stuff. It's like, what is the government doing promoting this, and it's a question. They're not promoting anything else. Hell, I don't even see any with red, black, and green. What about to be fair, a Johnny Reb something down there? Or even good old US of A down there. You don't see any of that, but you see this rainbow stuff, and it's kind of offensive, really. I mean, it's their right to be what they want, but I paid a lot of taxes over the years, and I resent my tax dollars being used to sustain somebody's ideological perspective.
Right.